If you've recently been involved in a car accident in Wisconsin and you've never hired a lawyer before, you probably have a lot of questions about the process. Common questions that people have are, what documents do I need? Do I even have a case? How much might this be worth? What does insurance actually cover? What happens if the case doesn't settle? How much will a lawyer charge? In this video, I'll walk you step by step through the entire Wisconsin injury claim process, from the very beginning to the very end. Before we do, let me introduce myself. I'm Craig Steger, and I'm a personal injury attorney practicing in Wisconsin, Minnesota, and Iowa. Our main office is in La Crosse, Wisconsin, but we handle cases throughout these 3 states. Let's begin with what you should gather as soon as possible after the wreck. Even if it's been days or weeks after the crash, you should try to obtain and preserve some of the following. If you hire an attorney, your attorney will actually get these items for you. One of the first things you want to get is the police file. You want to request a copy of the official crash report. It typically includes things like names and contact information for those involved, whoever was the owner of the vehicles, insurance information, vehicle descriptions, witnesses, road and weather conditions, officer observations, whether anyone was issued a citation. If you were issued a citation, you want to call an attorney immediately to see if it can be challenged. If it goes unchallenged, it can defeat a possible injury case for you. The police report often becomes a reference point for all insurance evaluation. Next, let's talk about video footage and photos. The police will often take photos of the vehicles at the scene. Usually you have to request those separately from the accident report. Most police cars are equipped with dash cams, and most officers wear body cams when they're at crash scenes. And these can have really important information about the scene. Be sure to ask about these as well. Preserve any photographs you or other people may have taken at the scene. Especially includes things such as location of the vehicles after they came to rest, where the vehicles collided, any vehicle damage. Get some wide intersection views. If there's any pictures of the road conditions, whether airbags deployed. You don't want to rely solely on insurance companies for photographs. You want to keep your own copies and give those to your attorney if you hire an attorney. You want to get insurance documents. So you want to try and get the other driver's insurance information. You want to make sure you gather your own auto insurance information. Make sure you notify your own insurance company as soon as possible after the crash, even if it wasn't your fault. Now, your declarations page is what your own insurance policy has. It'll indicate things such as liability limits, medical payments coverage, uninsured motorist coverage, and underinsured motorist coverage. It'll indicate whether you have coverage for rental vehicles if you need to do that while your vehicle is being repaired or replaced. You want to talk to your attorney as soon as possible before giving a recorded statement to even your own insurance company, and you should never give a recorded statement to the other driver's insurance company. Let's talk about medical records and bills. If you can, you want to obtain copies of any emergency room records, ambulance records, imaging studies such as x-rays, MRIs, CT scans, physical therapy notes, any specialist evaluations and recommendations. You want to have your itemized billing statements. These are the foundation of your injury claim. Once you have an attorney, they will gather a lot of these things for you. If you missed work because of your injuries, you want to keep things such as your pay stubs. If you have any disability coverage, you want to get that and get a copy of that policy. You want to document any PTO or sick leave you had to use because of missed doctor's appointments or being unable to go to work. This is how your lost wages will be supported to pursue a claim later on. For a lot of people, a car accident may be the first time you spend much time making use of medical care. Now, even if you lack health insurance, your med pay coverage on your own auto policy should help cover these initial costs. If you were working or on the clock at the time of the crash, you may also want to submit a workers' compensation claim. Sometimes you're entitled to both workers' compensation and personal injury damages, and an attorney can help you navigate that to make sure that you get the maximum recovery. You see, medical care is going to be central to the claim process. This isn't a good time to tough it out or hope it goes away. Delays or gaps in treatment are the biggest thing insurance companies look for when they're trying to downplay someone's injury and minimize what they have to pay. If there's a long delay in care, they may question whether the injury was even related to the crash. Now, if your injuries will interfere with your ability to work, you want to make sure you ask your doctor to give you work restrictions, and they should document these in the medical records. Now, be aware, everything you say to your doctors can and probably will end up in the medical records, so be mindful of that. This goes for both the good stuff and the bad stuff you say. If you're referred to specialists, follow through with that. Have those appointments. Now, often if you go to the emergency room or urgent care, they'll tell you to follow up with a primary care physician. You should do that and don't delay. Gaps are the insurance company's best friend. Now, it's common to order x-rays at ER visits, but more advanced studying like CT scans and MRIs are often not ordered right away unless there's a pretty serious injury. A lot of times they will have you do what's called conservative care first, such as physical therapy or maybe chiropractic care. If your first care after a car crash is a chiropractor, I encourage you to also see and establish care with a physician or other primary care physician. Physical therapy can help with your recovery and can help document any functional limitations you're experiencing in the days, weeks, and months after a crash. Now, if physical therapy or other conservative care doesn't improve, usually your doctor will order more aggressive imaging such as MRIs and CT scans. Now, you see, unlike x-rays, these can actually see injuries or damage to the muscles and tendons, and we call those soft tissue injuries. Now, you may be wondering who's going to pay for these medical bills, especially if the crash was someone else's fault. Now, generally, your bills are going to be paid by 2 or 3 sources. First, if you have MedPay coverage under your own auto policy or the car that you are riding in, that will usually pay for those initial medical expenses and ambulance rides. Now, this is generally limited amount, so it's probably not going to cover all of your medical expenses, but it's there so that you don't have to worry about going to the doctor or the hospital right after a crash. Second of all, your own health insurance, whether it's a health plan, Medicare, medical assistance. I've had a lot of clients wonder about this because they don't think it seems fair that they should submit their medical bills to their own insurance if the crash was someone else's fault. Don't worry. That's their job. That's how this works. They'll pay your bills, and if you make a recovery later, they'll get it back. We call that subrogation. Now, third, if you were working at the time, now you may have workers' compensation there to cover those medical bills. They also will get repaid if you make a recovery later on. Now, one important concept that you'll want to be aware of is what we call maximum medical improvement, MMI. MMI means that your condition is stabilized enough for doctors to determine whether your injury is permanent, whether you're going to need any future medical treatment, whether you have any work restrictions that are going to be long-term. Most serious injury claims aren't really evaluated until after MMI because we want to make sure we know the long-term impact before we present a demand to the insurance company. Now, you may be asking, how do I know if I have a case? This is a common question that people have. Now, it depends on 3 primary factors. Number 1, who was at fault? Number 2, was there an injury? And number 3, is there any insurance coverage that can pay for it? You see, Wisconsin follows what's called a modified comparative negligence statute. If you're 51% or more at fault, you generally can't recover. That's on personal injury claims. That doesn't apply to workers' compensation. But if you're less than 51% at fault, you may be able to recover, but your damages are just going to be reduced by the amount of fault that's attributed to you. So to answer that question, if someone else was at fault, if you or a loved one was injured, and the at-fault party had insurance, you may have a case. Personal injury attorneys do not charge you for the initial consultation. It costs you nothing to at least call an attorney or a few attorneys. Then you can decide if you want to hire an attorney and which one is the best fit for you. Now, another question you may have is, how much is my case worth? Now, there's no universal formula. Case value typically depends on a number of main factors. Number 1 is how bad is your injury? And number 2, what is your age and your life expectancy? The younger you are and the more severe your injuries, typically the bigger your case. Now, there are 2 main categories of personal injury damages: economic damages and non-economic damages. Economic damages are those that can readily be valued, things like medical bills, past and future, lost earnings, vehicle and property damage. Now, non-economic damages tends to be everything else. Things like pain, suffering, disability, mental and emotional anguish, loss of love and affection with your spouse. Insurance limits matter a lot. What your claim may be worth may be limited to what's available in insurance. If the at-fault driver had minimum insurance coverage of $25,000 per person, that may cap your recovery unless other policies may apply. This is why having underinsured and uninsured motorist coverage on your own policy is really, really important. Now I want to talk a little bit about how insurance works in Wisconsin. So personal injury cases largely come down to insurance. You're required to have auto insurance to drive in Wisconsin. The minimum required liability coverage is typically $25,000 per person and $50,000 per accident. That means you have liability coverage for up to $25,000 per any person that's injured by you, and up to $50,000 per accident if multiple people are injured in the accident. Now, people can and should have much more than the minimum limits. If there's a commercial truck involved, trucking and commercial policies are generally at least $750,000, which helps if you have severe injuries. Now, your auto policy generally has the following main coverages. Number one, your property damage. Number two, medical payments coverage. We talked about that earlier. Liability coverage. That's if someone is injured because of your fault. In that case, the insurance company will hire lawyers to defend you and pay any damages up to the limits if you cause someone else's injuries. It should also include uninsured and underinsured motorist coverage. Uninsured motorist coverage is literally if the at-fault driver had no insurance. Underinsured motorist coverage is if they had insurance, but not enough to cover your injuries. Now, I want to talk a little bit about property damage. Property damage is typically handled between you and the insurance company, but sometimes we can help people on that if they're having a difficult time getting that resolved with the insurance company. If you've never hired an attorney before, especially in a personal injury case, you may not know how contingency fees work. So most personal injury cases are handled on a contingency fee basis. That means the lawyer only gets paid if we make a recovery for you. If we don't win, you don't owe the lawyer. If we win, the amount of the fee is simply a percentage of whatever is recovered. Now that amount can vary depending on the type of case, but it's usually between 30 and 40%. Now the fee agreement may also reimburse the lawyer for case expenses that they advance on your behalf for things like getting medical records, court filing fees, expert witnesses. If you call a lawyer for a consult, you have not hired them until you sign a written contingency fee agreement. A lot of times you can sign the contract electronically without having to go to the lawyer's office if that's convenient to you. Be sure to read it carefully before you sign. Check to see if you're responsible for case expenses, even if there's no recovery. Talk to multiple lawyers before you choose the one that's the best fit for you and you sign a contract. Now, if you get to the point where you have to contact a lawyer and you want to hire them, these are some of the things that they're going to ask you for, so you may want to have these ready. They'll typically ask you for the crash report if you have it, any insurance information, photographs and video from the scene and damage to the vehicles, any medical records and bills that you have. We can often get those directly after you sign a medical authorization. They'll ask you if you have any wage loss documentation, documentation about your health insurance, who your health insurance carrier is. They may also ask you about your prior medical history. Do you have any pre-existing injuries or illnesses? Do you know the names of any of the witnesses? Do you have any employment records? It's really important that you have this available to you and help your attorneys gather this as soon as possible so they can begin to build your case for you. Now, there are some legal deadlines that you need to be aware of. In Wisconsin, generally speaking, the statute of limitations for personal injuries is 3 years from the date of the accident. There may be exceptions to that. And this means that your lawyer needs to be able to file a lawsuit before that date. It's important that you don't wait until the last minute to talk to an attorney so they have the time to get the information ready and get your case ready for filing. If there was a government vehicle or employee involved in the crash, you may also have to provide additional notice to them, sometimes as soon as 120 days after the crash. An attorney can help you with that. Now, missing these deadlines can permanently bar your claim. There can also be shorter deadlines and exceptions that may apply, so it's important to talk to an attorney as soon as possible. I want to talk a little bit about the claim and demand process once you've hired an attorney. So once you hire an attorney, they really take over dealing with gathering documents and records so that you can kind of focus on healing and trying to get your life back to normal. Your lawyers will take over communications with the insurance company adjusters so you don't have to worry about their calls anymore. Your attorneys can also help make sure that you're getting seen by the right medical providers and specialists, and they can help deal with health insurance companies and work comp carriers. There's also a lot of waiting at first. We give you and your doctors time to work on your treatment and hopefully get you back to normal. After your medical treatment stabilizes, either you've healed or you've plateaued, the claim often moves into a formal evaluation stage. An insurance claim will have been opened as soon as you contacted attorneys. They'll let the insurance company know that a claim is being pursued. Your attorneys will send the insurance adjuster with updated information and documents throughout the process. And then once you've kind of reached that maximum healing, they'll help you prepare a demand package for the insurance company. Now, the demand package would typically include things like a summary of the crash. It may include the police report, an explanation on liability and why your attorney believes that the other insurance company's driver was at fault. They'll provide with medical records and medical summaries, medical records and bills, wage loss documentation, photographs and video if it's available. They'll have a description of the long-term impacts of the injuries on you and your family. Now, a demand usually includes a specific dollar amount that may depend on what the insurance policy limits are. Your attorneys will usually recommend a settlement range to you, but ultimately you get the final say on all settlement offers. Negotiations then follow. The insurance company, when they receive the demand, may accept it. They may reject it outright. They may counteroffer. Maybe they'll request more information. If an agreement is reached, a check will typically be sent to your lawyers, and then they'll have you sign a release agreement. Now, sometimes an agreement can't be reached, and your lawyers will have to start a lawsuit. It's not unusual for certain insurance companies to really refuse to pay fair money until a lawsuit has been started, and they have to go hire defense lawyers. Now, filing a lawsuit does not automatically mean that your case will go to trial. In fact, the vast majority of cases that do get filed eventually settle before trial. But a lawsuit moves your case into the court system. That includes filing a complaint. The defendant and the insurance companies then get served by the sheriff, and then they file a written answer. And then the lawyers involved in the case will do what's called discovery. They'll send written requests for information and documents. Your attorneys will help you respond to the requests that are made to you. Depositions may be taken, both of you and the other driver and any other witnesses. Experts may be involved, and they'll offer opinions, people such as accident reconstructionists, medical experts, maybe your treating physicians. Typically, the parties will then come together for what's called formal mediation. This is with a neutral third party. Usually it's an experienced attorney, maybe a retired judge, and they will try to help the parties see if they can reach a resolution without going to trial. Many cases do resolve during the discovery process or at mediation. But if a settlement can't be reached, the case then proceeds to trial, usually a jury trial. The jury will then decide issues such as fault and who has what percentage of fault, and they'll decide whether damages should be awarded and how much. Trial outcomes are never guaranteed, which is why many cases do actually resolve before going to trial. Now, after any resolution, whether it's a settlement or a verdict, certain things will have to happen. Now, medical liens will have to get paid. Any subrogation claims, so health insurance, workers' comp, things like that, will have to get addressed. Any case costs and case expenses will be reimbursed, and then the funds will be distributed. Now, payments from the insurance company usually go to your lawyer's trust account, and then you will receive a check from your lawyer's office. That final stage ensures that all legal and financial obligations are satisfied. I hope this was helpful. If you have any questions about any of this, please let me know, or reach out to me at the phone number on the screen, or go into the description to get a link for how to get more information.